Stay tuned for Legal Straight Talk.
Is this reality? No, I don't feel okay. I need my kaleidoscope of colors to lead the way. I'm riding in my car and I'm coming on around the bend. It's a chase, this twisted race. I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole 9 yards or nothing.
Welcome to Legal Straight Talk. I'm Brett Harrison. Today we have another special guest who handles divorce and family matters. It's Al Hedayati. Al, thanks for coming in today to Legal Straight Talk.
Thanks for having me, Brett. It's a pleasure to come and see you on the show.
Today we're going to get right into it. Divorce. It's what everybody fears, but it ends up being an absolute that happens. I think it's now, what is it now? Almost 50% of marriages?
It's definitely over 50%.
At least in Long Island and in New York.
At least in Long Island, it's more than 50%. You know, people just deserve to be happy, Brett. And when they're not happy in their relationship, they just need to understand that it's a separation, like any other. When you're going out, boyfriend-girlfriend relationship. However, when you're married, you're going to have some financial consequences and obligations and liabilities, depending on whether you have children or not, whether you have assets or not. So it's just basically, you have to understand.
You have to face it. You have to face it. When you've come to the point when you say, you know what, I can't take it anymore, I want out. It's unlike past generations, people from, that were born in the 30s and 40s and 50s even. A lot of them just stuck out marriages for the children or what have you, or due to religious reasons or whatever. They just stuck it out, and they said, you know what, I'm married for good and for bad. Nowadays, it's not for good and for bad. It seems people want to get out of marriages much quicker. I'm not so sure if there's more financial equality between men and women.
I think that's it. I think you just nailed it on the point, Brett. I think the main reason doing this for as long as I've done it and my firm, we have people with many years of experience, of what I see every day is financial or wage equality between men and women has allowed women to make that decision to basically say, you know what, I've had it, whether I'm in an abusive relationship, but you know what, before people couldn't do it. It's like during the economic downturn a few years back, divorces started slowing down because it's cheaper for two people to stay in the same house. Economically, your divorce case can't be pending, and the husband can't just go rent an apartment and do what he wants to do, or vice versa. Women and men should be treated equally.
So, what's interesting is you brought up the point of economics. It seems as if as we've gotten, to the 1980s, 1990s, 2000, 2010, 2015, a lot of it is based on economics. Initially, as we just started to talk about, a lot of women back in the 60s and 70s and even 50s and 40s, they would stay in a marriage because economically they couldn't afford to support themselves. They
didn't have that option.
Right. Now, again, when there's a downturn in the market, people often stay together but also live separately within their own house.
It's like putting up a wall. A lot of clients ask me, can I just put up a wall in the house? No, but generally what we do is one spouse lives in the basement, one spouse lives above. But, when the times are good, you have a better chance of getting exclusive occupancy, for example, which means one spouse stays in the house while the other one leaves the house. But when the times were tough, what we noticed more and more is obviously judges have to make reasonable decisions, and they said, well, if you can't afford two households, then you're both going to stay in the house and act like adults.
Well, let me take you a step back. I was just reading an article about a week or two ago from Money Magazine. It talks about planning for divorce, which was an interesting concept. If And it basically was talking about if you know you want out and you could actually plan and you're not served with papers for divorce, what financial steps can you do or what type of preparation can you do before you see an attorney, before somebody comes to your office and says, you know what, Al, I want out. Serve the papers, or what can I do? What should they do prior to if they're thinking about divorce? What's a good plan of action?
Well, a good plan of action is always see an attorney for at least a consultation. When the article you read isn't really saying be deceptive and hide your assets.
No, it wasn't
before
saying
you
that
get a
at all.
divorce. No, it's understand that divorce at the end of the day is going to be all financial. Understand what you're going to be giving out if you're the moneyed spouse, if you're the the spouse that's been earning more money or all of the money in certain relationships, and understand what your responsibilities are going to be before you even start the action. And that's something that our office does all the time. And you know what? We're able to tell people, could they live after a divorce? Could they survive financially? So the article you're referring to was a great article. I did take a look at it, but it's more life after the divorce financially. And is it sustainable?
But what they were talking about also is in preparation prior to going to the, because let's face it, people are concerned that I don't want to pay my divorce attorney $20, $30, $40, $100,000 when there's not that much there, when there's not that much money between in our joint account.
Well, that's why when someone comes in, I mean, that's the number one complaint about the divorce. I'm paying all this money to my lawyers. But what they need to understand is that if the client keeps the emotions out of it, which is very tough, it's easier said than done, you know, it's going to cost you a whole lot less. You can do a divorce as an uncontested if you have a financial plan and you express the plan to your other spouse.
Let's talk about, you brought up the word uncontested. Can you explain to our audience, take it out of that legalese. What is uncontested, contested?
Well, interestingly enough, all the attorneys on the island give it their own definition. But what an uncontested is, legally, is when your case does not go to the court and for you to see a judge, okay? So basically you and your spouse decide that we're going to sit down around a table, whether both of you are represented or not, doesn't matter. Everyone has the right to have counsel to read the agreement. But what you want to make sure is uncontested, you know, it could be done almost in every case if parties left the emotions out of it. Because everything is a formula. New York State has a formula for child support. New York State, you know, we, as experienced matrimonial attorneys, we certainly can come up with a formula for maintenance or alimony after the divorce, not necessarily the pendente lite, which is more in contested matters.
So is the first question when a client comes in, besides, you know, do you have children? Do you have pensions? Are you both working? Do you own a house? Do you have debts? Which is all part of, again, the financial picture. Is the first question you're going to ask is it going to be contested or not contested?
Well, right, but we don't ask it like that because most people are not going to know the difference. So what I ask always, my first question is, how is your relationship with your spouse?
Well, if it was good, they wouldn't be going.
Yeah, but no, sometimes people we do plenty of uncontested. Not every case is contested. So a lot of times we can talk to the other side. Sometimes both people want out. You know, they just want to be happy. So it's not, you know, if we are more optimistic about a divorce than pessimistic or negative, then you're going to get out of this quicker, cheaper, more cost efficient, and you know, you're going to keep your sanity and keep your money. I mean, and move on with your life, and that's what divorce is all about.
But the reality is, to me it seems, is that most people, when they're getting a divorce, one or both may feel slighted. And one may have, let's say, the money, and they say, you know what, since my husband or my wife is going to be paying for my attorney, or a good percentage of the fees, since he or she's going to have more money when they leave me, I'd like to drain him a little bit.
Well, you see,
or he or she.
But certainly with someone like that, you're not going to be able to do an uncontested. And usually those cases have a very, very different start. And what I mean by that is if your spouse has that kind of mentality and intent, then what she's probably going to do is call the police, and we see this every day, call the police, say he hit me or she hit me. It happens both ways. And from there, the police get involved. There's an order of protection. I mean, everyone on Long Island pretty much has a family member that's gone through a divorce or family cases of what I'm referring to right here. But the most important thing is if you know you have someone like that, then you have to act quick and you have to protect yourself. And I say this to a lot of people, and of course, you're going to know who your spouse is or how they're going to react. And what I'm talking about when it's perfect, uncontested, is you have two reasonable people. They've already talked about it. They both want out. They both want to move on with their life, but without thinking spiteful in a spiteful manner. And they're not looking to burn the other person, though they want what they're entitled to.
But you know what you hear from a lot of people that go through divorce? Oh, my husband or my wife got this real SOB attorney. He's going to go after everything. This guy or she or the matrimonial attorney is going to charge X dollars. They're not going to settle. They're going to make myself or my husband spend a lot of money. Now I got to, what do they call it, lawyer up, as they say?
Yep.
And then I got to play games. This is what most people think. And you know what? You read about it in the paper,
And that's
all the
absolutely
movies.
true.
It is true.
There's no way around that, and that's true. And the interesting thing is, when someone comes in, if they've been served with papers, then I could easily tell you exactly what kind of case this is, and I can give you a ballpark figure as what it's going to cost.
Is that
because we know all the other attorneys?
It's based upon who that attorney is.
There are
He or
attorneys out
she
there
are going to say
he or she have bad reputations for billing practices or dragging cases on, but there are also very reasonable attorneys out there who we know we can work with, and most of them we can work with. I would rather personally work with an attorney on the other side than someone who is self-represented or pro se litigant. And the reason for that is it keeps the emotions out of it. Because at the end of the day, as attorneys, we know our responsibility, and if we can deal with someone with the knowledge and the know-how of this area of practice, then it makes it that much easier.
But what's interesting about this area of law is I see so many times that a client or litigants, they switch attorneys. Is that some of it seems to be is to stall, or some of it is because are they just that unreasonable that they want to go to another attorney that sees their point of view?
Well, that happens quite a bit too, and
more than in other area of law. I've
well,
noticed.
of course, because
Why?
because they feel like, let's just an example is a client comes to me and says I want X, Y, and Z. I tell them X, Y, and Z is not going to happen, but I can get you X, Y. Z is not going to happen. By saying that, some other attorney out there will probably go tell them, well, I can get Z done for you. And so, they butter them up and they fire them up, and then they want to go, in a more contested manner because, again, they're keeping their emotions in the case. So the best word of advice to anyone out there going through this kind of a case, hopefully they're not, but it happens. And it happens quite too often. So, is try your best to keep the emotions out of it. Whether you're going to have a contested case or an uncontested case based on who you've married and who you've lived with at least for several years. And you know what? That's the person you chose to marry. I always say this, though it sounds cold, but you chose to marry that person, and getting out of it is going to be problematic if you know what you got yourself into.
Right.
And if you come together to the table and want to do it uncontested, then that happens quite often. I would say about 70% of our cases are uncontested. So it's not like, a big, because this is what we're trying to promote. Because at the end of the day, it's all a formula. It could be figured out from the beginning, depending on what assets you have, if you have children or you don't, if you own a house, if you have a pension. And at the end of the day, there's something called equitable distribution. And these assets, and they would have to be distributed.
What would fall under, explain what equitable distribution is and what would fall under that concept of equitable distribution?
Well, equitable distribution just means fairness. New York is an equitable distribution it's a state. But, there's common law states out there that say everything is 50-50. Equitable distribution starts at 50-50, basically split on assets that have been acquired during the marriage.
That's the key?
That's the thing.
Acquired during the marriage?
Acquired during the marriage. So anything you've had before marriage, depending on what type of asset it is separate property, and they could make a claim for it.
But what if, you had it prior to? Let's say you had a house or some type of equity of stock or some asset.
Well, here's
when you came into the marriage, it was worth, $50,000, and now through the time, it's now worth $300,000. Let's say if it was a house, you improved the house, or you've made it bigger, you've had consistent rents. Does that become now part separate
No,
and
but
part
there will
joint?
be a separate. There will be a claim for it. What I mean by that is that A, it depends on what the asset is. B, it depends on what was done to get that increase in value.
Was joint money used?
Was it that, let's say I'm the husband, not necessarily joint money, but let's say it's a business, right? Or even a stock. What's really done to increase the value of a stock during the marriage? Nothing. So that more likely than not will remain separate property. If a house, for example, if the mortgage payments during the marriage are being paid from a joint account, or then there is going to be a claim by the other
Okay,
spouse for a portion of the increase in value.
Let's say prior to getting married, you bought this house for $120,000. Okay. Now, 15 years into your marriage, you now have a family. And you say, you know what? Let's just build up. Let's put $200,000 into this house. This all occurs while you're married, and let's say it comes from the joint account, regardless of who puts money into that joint account, but it all comes from the joint account. Would the married spouse now have a claim to at least the improved part?
Yeah.
And
More
then
likely
offset
than not,
against
it
the
would
100?
have to be argued. Again, because the property was acquired prior to marriage, it's going to be deemed to be separate property. Now the other spouse the spouse not owning this property will have to make a claim and try this. This is a tribal issue that neither party is probably going to concede on. So there definitely will be a trial on that issue to find out exactly what percentage of that improvement was resulted in an increase in the value of the home. So that's something that would be contested. There's no way around it unless the parties agree to a number and they both agree to it.
Now, this was an interesting situation that you and I talked about this off air. There are now union plans where, for example, you pay into a union, they have legal programs or that you're automatically part of, that you don't have to pay for your attorney for divorce. Now, that has a large effect on the one spouse because they're going to say, you know what? It's not costing me anything. I don't care. Let it go to trial. I have much more bargaining power because I'm not paying for my attorney.
Absolutely.
And that happens.
And the law in New York State changed a few years back where the less moneyed spouse, the person making less money, could make a claim for legal fees, counsel fees, either during the pendency of the case or at the end of the trial. So in a case like that where one spouse basically had a union job during the marriage and now has a union attorney who he doesn't pay anything for, and we have plenty of cases like that, the spouse not having that union job or the union attorney would have a very favorable, probably, outcome, either during the pendency of the case asking for legal fees or at the end of trial, because the judges are going to look at one thing. They're going to look at the other party spent no money on legal fees.
Exactly.
And that's going to have a huge effect on how much the less moneyed spouse or the non-union spouse gets.
But the reality to me is I'm questioning now, if you wait till the end, I don't know how many attorneys are going to work years on a case without getting their money and then saying, well, then you can go after him for the money you gave, that you gave me. So they may not have the money again or be able to find competent legal attorneys that are going to handle it and wait for the end. And what happens at the end if the judge says, you know what, I see that you spent $70,000 on legal fees. You know what? I'll give you $20,000 towards it. This person still has got to lay out $50 or owe the attorney $50.
Yeah.
What are they going to do? Collect it from the assets? They're going to say, well, why didn't I just settle and give him he or she?
That's why they probably should have.
It's positioning again.
I'm going to give all the attorneys out there the benefit of the doubt and say I'm sure that was an advice that they give at the outset of the case, and it is something that we do at my firm. And you always want to let them know if the case goes to trial, our client is always responsible for the fees. Whether we get the order granted or not for the other spouse to pay the fees does not mean that it relieves my client of the liability to me and their responsibility to me.
But how are you going to get, let's say you don't have the moneyed spouse because the other side's on a union program. Your client doesn't have much money. They have a regular job and just getting by. this case they need certain experts that could cost $2,000, $3,000, $4,000. Are you if they can't lay it out, do you have to lay it out?
Well, Brett, initially, in any case, if it requires these types of experts, depending on the assets and what we're really looking for, the
Right.
key here is to file what's called a penente lite motion early on, which just means it's paperwork to the court, in layman's terms, which you're going to request certain things from a judge. For example,
like what?
Maintenance, temporary maintenance during the pendency of the case. You're going to ask for temporary child support during the pendency of the case. You're going to ask for certain insurances to remain in full force and effect.
Seems only fair.
You're gonna. I'll go into that later, but you're gonna ask for counsel fees, and then you also can ask for expert fees during the
If
during
you
the case,
anticipate it.
If you're anticipating it, so you do that early on, and that way you preserve your rights early on, and a judge will rule on that and will grant based on the credentials of that expert. That's what they always ask for. So don't just ask for it. You actually have to have experts with their resumes in there and their fees and what the cost will be.
But don't you have to show why you're going to need those experts?
Absolutely. So you can't just frivolously say, I need this expert, this expert, this expert. It really has to make sense in the case for the judge to grant it, and then you ask for the moneyed spouse to pay for it. So if, you got it, the legal thing to do is to do things right from the get-go. A lot of clients are like, well, he's not doing this, and we have to run to court. But, you're hoping that everybody is going to listen to a judge and the order. I mean, at the end of the day, if they're held in contempt or in violation of an order, then the judge will address that when that happens. So it's a very long, tedious process for clients because it's their life, it's their children are being affected.
They've also invested, whether it's 5, 10, 20, 30 years into this marriage, gave up opportunities, which I would think should factor in.
Absolutely. We hear that almost in every case. Every case is different, but one spouse always says, I gave up this. Now I'm 50 years old. What am I going to do the rest of my life? I gave up my whole life.
I haven't worked
for
10 years, or
I haven't worked. That happens all the time, and to get back into the workforce is not an easy task. But that's exactly what that motion is for.
Is it to keep you in as close to the same?
Well, you got to. It's called
prior
status
to
quo. Keep you at
in the status quo.
Yeah. So when
It's
a
not to give
divorce
the
is
other one an
initially
unfair.
filed and served on the other party,
Right.
there's an automatic stay. So it basically says you can't cancel car insurances, you can't change anything, transfer assets, you can't sell assets, you can't put everything in your family. So once you're served with that, you're put on notice at that initial phase.
Let's say they do. Let's say you do transfer an asset, or you do take a loan on your pension. What are they going to say? If you say, oops, I did it, I'm sorry. Are they better off begging for forgiveness?
No.
What could happen to them?
If that happens, it just gets credited to the other person.
But they got to use the money to do whatever they wanted.
Yeah, but at the end of the day, things are going to be divvied up. And at the end of the day, if let's give an example, a husband took out a pension loan, that's going to be credited. And the wife will not lose the share that she would have had. If you can prove it was done, within months of the divorce being filed, if it was done intentionally to take some money out. I mean, if money is taken out to pay bills and mortgages, you're not going to get a credit for that. But if it's taken out and he can't explain what he took the money out for, then you certainly could do that.
It seems a lot of this is like an economic shell game. Who's in the better economic position?
Obviously, the person in the better economical position because they can last longer in litigation. And many attorneys don't like their, legal fees accruing to thousands of dollars, and then they got to get ready for trial. And trials do take time, Brett. They take a lot of preparation. They take a lot of subpoenaing people to come in to prove their side.
And you also have the judge's schedule. It doesn't just happen like that.
It takes time. It certainly takes time.
What's the typical time if you get a case and it starts as contested from the start? Let's say it's January 1, 2015.
Probably anywhere between 18 months to 24 months before trial.
Huh.
So that I would say that's where the average would be, because there's a stage like any other area of law called discovery. So that discovery stage takes time. But in a divorce,
and they don't always, from my understanding, they don't always turn over all the documents. Well, I want to thank you for coming in. I know we just got on the tip of the iceberg.
Is that quick?
It's that quick. We're going to have a part 2 on this, and maybe a part 3 and a part 4.
Yeah, there's a lot to talk about.
I do want to thank you for coming in, and we'll get Mr. Hedayati back, and we'll badger him with some more questions.
Thanks for having me, Brett. Have a good day.
Thank you.
Hi, I'm Jerry Parisi. Welcome to tonight's version of the Long Island Filmmaker Show, now known as the Filmmaker Show. Hi, I'm Jerry Parisi. Join Tom Neely and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.